Okay, good afternoon, everybody. Welcome to the OFIS Winter Webinar Series on School Safety Policies and Procedures. I would like to welcome you all to our first session this afternoon and introduce you to our presenter for today. This is David Ferguson, who will be presenting a few of these webinars during this series, and today he will be talking about child protection protocols, safe arrival and safe access protocols. And David has lots of experience. David has been the principal of a private school for many years now, sort of retired, and David does some consulting work with OFIS, but does consulting work on his own as well with some other topics, particularly around university preparation and college preparation for students, and he's worked with many families and many schools over the years. So we welcome David to the OFIS platform today, and David, I'm going to turn things over to you now.
Great, thanks a lot, Barb, and hello everyone. I noticed from the list of participants that I am already familiar with a few of you, so I'll say hello to Dina and Naz, and say hello to Jason as well. Perhaps over the next year or so, I'll get to know more of you, but in the meantime, what I'd like to do with you today is just to provide you with an overview of the types of protocols, procedures, policy type questions that you should be asking yourself as a provider of educational services in the province of Ontario. You will note as we go through the various slides that a lot of the policies and procedures that we will discuss are linked fairly substantially to the policies that are part of the Ministry of Education's guidelines for schools in the public domain. The reason why we use those policies and procedure guidelines is because there are few pieces of legislation that are directed specifically at private schools. But research has shown, and history bears out, that when it comes to questions of implementation of policies with respect to education, that the court system in this province tends to hold private schools to the same standards that are expected of public institutions. So,
David, sorry, it's Franklin Smith here. I'm just going to excuse the interruption. I'm just going to remind you to please turn your screen sharing on when you get a moment so people can see the slides.
Is it on?
Now it is. Thank you.
Are people seeing my slides?
I think the answer is probably yes.
Okay.
I am this is Barb. I am seeing them, David, so I'm assuming everyone else is seeing them as well, and I'm now going to mute myself.
Terrific. Okay. Sorry, folks. A little glitch there, but I think we're back on track. So just to reiterate that last point, in case anyone missed it, we are going to be looking primarily at legislation in the province of Ontario governing safe schools and safe arrival and school access. And we're using documents that are primarily focused on public institutions. And the reason we are doing it is because even though we are private institutions and therefore not necessarily subject to the same rules and regulations as the public schools, it is clear through research, and the history bears out, that private schools are held not only by the court system but by the public to the same standards expected from public schools. So you are serving your own best interests if you design and execute policies that are in line with those set out by the major pieces of legislation governing education in Ontario, and by using the policy and program memoranda that have been provided to you through the Ministry of Education. So have a quick look at the slide entitled The Legal Hierarchy, which shows you the hierarchy of legislation that governs education in this province. I've arranged it in such a way that it is indicative of the primacy of each piece of legislation. So the Charter of Rights and Freedoms is the supreme law which governs all else. In this province, the Ontario Human Rights Code and the Accepting Schools Act, Safe Schools Act, and Child Care Act and Early Years Act are the pieces of legislation with which you should be familiar. You will notice at the bottom of the slide that the school policy, which is what you will be charged with putting in place, is going to be reliant on the rest of those pieces of legislation. I would also note that the three pieces, the ASA, the SSA, and the Child Care and Early Years Act, are all acts that were implemented as a method of revising the Education Act to reflect current thinking in education, and to reflect the fact that over the last number of years, the whole notion of safe and inclusive education has come to the forefront in terms of educational philosophy. So the Charter itself, as you know, is part of the Constitution. All the other laws that are in place are subordinate to that law. But you must ensure that whatever you do in terms of your particular policies and procedures are consistent with the rights that are enshrined in those higher ranking laws. And this would also include the Human Rights Code and the Charter. So it's not enough just to take a look at, say, the Education Act itself and leave it at that. There are other pieces of legislation that are as important to the process as the Education Act. The Education Act itself is the primary piece of legislation which gives you the authority to create schools in the first place, and it outlines the creation of all the main features of the education system. The Education Act is the law that empowers and assigns responsibility to the Minister of Education and to schools, which means you as a principal and your teachers. All of those have rights and responsibilities that are carefully spelled out in that legislation and other pieces of legislation, which we will get to later in this seminar and in subsequent presentations. The Safe School Act, which is the first one that I'd like to look at, Bill 157, is an act that was put into place whose intent was to manage student behavior. One of the things that has been of concern to many people in education over the last 5 years in particular is the prevention of unacceptable behavior and means by which intervention by school officials when unacceptable behavior occurs take place, and how we go about supporting all the parties involved. Because this has become such a bellwether issue in the last little while, there's been a great deal of concentration on things like developing codes of conduct, which are statements of the school's position with respect to unacceptable behavior, and which is based upon the Provincial Code of Conduct, which you can find at the Ontario Ministry of Education website. As a school, as many of you already know, you need to set out, publish, and practice a policy of progressive discipline, which means the principal will consider the most appropriate way to respond to each situation individually. This is important because it eliminates what used to be the policy in the province, which was zero tolerance. That policy is no longer appropriate. What you need to be looking at now is the development of policies which reflect the notion of progressive discipline. I'll get into what that means a little later this afternoon. These types of policies, however, are collaborative. So it's not sufficient that the school itself determine what the policy is. It needs to be outlined in collaboration with students and parents, and progressive discipline itself could include such things as meeting with parents, writing assignments, counseling, or some combination of different types of intervention. The status quo in previous years, and in many of the years where I was running the school, was to leap almost immediately into some type of punitive situation with a student that involved in-school suspensions or suspensions outside of school or expulsion. And we've now determined that that type of discipline is relatively ineffective at affecting positive change, not only to individual students, but also changes to the school climate in general. Suspension and expulsions are, however, still a part of the process. The change that was made by the Act was that whereas in the past anyone involved in the school, teachers included, were able to affect the suspension under certain circumstances, these days that power is reserved for the principal only, and the principal will only exercise that power once he or she has taken into account mitigating factors and how that action might affect the continued education and development of the student. You need to have a right of appeal, and you need to enshrine that in your discipline code. You need to know that by law, suspensions are limited, and that there are conditions set down for suspensions of various lengths. So if you are going to suspend as a result of an incident, you must understand that you must provide an academic program for any student who's suspended for 5 or more days, and you must provide academic programming and counseling for any student whose suspension lasts for 10 or longer days. One thing that I'd like to point out also, because it's not often well understood, is that if you decide that the only resort that you have as a school to control a student's behavior is expulsion, it doesn't end there. Your responsibility to that student does not end with the expulsion. You have a duty to assist that student and their parent in locating a new school for that student, or failing that, to design and implement a program that allows that student to continue their education. That is something that many schools seem to forget when it comes to exercising that particular consequence. If at some point you decide that allowing an expelled student to return to the fold is in order, then you need to put together something called a student action plan, which indicates the conditions under which that student is permitted to return and the potential consequences of that return to the school as a whole, and what consequences you will be forced to impose should that student fall by the wayside once again. So it's important to remember that your obligation to the student doesn't end when you decide that that student is no longer acceptable to you as a student in your school. Moving on, the Accepting Schools Act, Bill 13, which came into effect in September of 2012, also made changes to the Education Act. Its major focus for most people tended to be on bullying. I'm not going to deal with bullying in this particular webinar, but will down the road, I think in webinar number 4, sometime early in February. But aside from its provisions on bullying, The Act requires you to support students who want to take leadership roles in your school in terms of organizing and running activities that are designed to promote a safe and inclusive school environment. So you are obliged, should a student or students come to you with an idea for an activity or an event that promotes school safety and promotes inclusivity, you are obliged to assist them in the development of that activity and to provide them with opportunities to carry forward their ideas. It's also important that the school itself take a proactive role in this regard as well by encouraging students to take these types of things upon themselves. The reason why this is encouraged is because there's nothing more effective for promoting school safety and school inclusivity than involving the students themselves in the planning and execution of these activities. So it's for your own sake as well as for the sake of the students that you get them involved. This Act codifies many of the components of existing ministry policy memoranda. Now, I'm not going to go through each one of these memoranda, but you should take note of the ones that are particularly applicable to this particular issue. The Accepting School Act recognizes that a positive school climate exists when all members of the school community feel safe, included, and accepted, regardless of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identification, gender expression, age, marital status, family status, or disability. Wow, that's a mouthful. The reason why two of those are in red is because these particular elements are new to the fold of the conditions that you must abide by in terms of being inclusive. It is important to understand this obligation and important to understand that the school, again, must be taking positive steps to include everyone, regardless of these particular characteristics. I hope everyone knows what gender identification and gender expression is, but if not, you can ask at the end of this presentation. One of the things that you might note as being an example of how that sort of thing can be incorporated into the school is found in the necessity for schools now to have gender neutral washrooms. Good example. All right. Schools must actively promote, as I said, positive behaviors and interaction. Aside from the things I've mentioned so far, my advice would be that principles of equity and inclusive education must be embedded in the curriculum. So when I say learning environment, I'm not only talking about the ethos and the climate promoted by the school, but also in terms of incorporating these types of things into your curriculum. Of course, keeping in mind that you want to introduce these things, taking into consideration a student's age, their degree of maturity, and their psychological readiness for information. So anything you can do to promote a positive school climate and a culture of mutual respect would be a good thing. I know an elementary school in the Peterborough district that promotes mutual respect and a positive school climate by having an all-school assembly or meeting on a daily basis in the morning where people share ideas and share their feelings about how school is going and how they're personally dealing with their challenges. It brings all the students together in one place and shows them that There are a lot of things happening around them that they may not be aware of, and it also gives them an appreciation of the challenges faced by many of their classmates. As a private school, you will always need to act in the same way that a board, a public board, would act. As a consequence, you should consider implementing policies that reflect the current norm in the form of public opinion. This may save you from the potential liability arising from disputes between you and your clients. What does this mean? Well, it means that aside from the legislation and the rules and regulations that we've spoken about, you also need to keep your finger on public opinion, particularly the opinions expressed by your particular parent group. I know some schools do have parent councils, others do not, but a parent council is a good place to solicit public opinion. Obviously, there are times when the opinion of your parent group may not be possible for you to implement if it clashes with your obligations under any of the pieces of legislation that we have discussed so far. Anything that promotes exclusivity is going to be a problem. Therefore, private schools should follow the Policy and Program Memorandum 119 and develop and implement an equity and inclusive education plan for their school that has the following areas of focus. It must contain school policies, programs, and practices. It must show collaborative and committed leadership, school community interactions, the inclusive curriculum that I mentioned already, and assessment practices for that. Religious accommodations where appropriate, school climate, and more important than ever, professional learning opportunities and accountability so that your staff can be included in and a part of and responsible for the creation of this climate. That brings us to the Ontario Human Rights Code. What responsibilities does a private school have? Well, according to the legislation, you have duty to accommodate students with learning exceptionalities, and you have a duty to accommodate student disabilities. That's what the legislation says. So in order to have opportunity to access education equally, students with exceptionalities may require a variety of different accommodations. We all know what those are. I've listed a bunch of them there. I don't think I need to go through all of them, but you get the idea. The idea is that the legislation demands that these kinds of accommodations be made. We have to identify and remove barriers that impede the ability of persons with disabilities to access educational services. There is a disability policy that's part of the code. You need to pay attention to that. Having said all this, all right, private schools in Ontario are not public institutions. So as I indicated earlier, this is one area where private schools are not obliged by law to make accommodations. However, you have a duty up to a point of undue hardship to provide equal access for persons with disabilities. So, should someone bring an action against you in a court, it won't be sufficient for you to argue that as a private school you're not covered in the legislation. The judge is going to look at your situation and he or she will decide whether or not it's reasonable for a parent or a student to expect that you will make certain accommodations. And the rule of thumb that they will follow is the rule of undue hardship. In other words, you are obliged to provide equal access and to provide accommodations for students with learning exceptionalities insofar as you can do so and not suffer undue hardship. So you may face a situation where a prospective client may rely on the code and other pieces of legislation to argue the degree of inclusion within their schools. In these instances, the school may be able to rely on an argument of undue hardship to claim exemption from the legislative requirement. There are only 3 considerations that a judge will make when assessing whether the accommodation being requested would cause you undue hardship. Number 1 is cost. 2, whether there are sources of outside funding that could be used. And 3, health and safety requirements, if any. So in other words, if the health and safety of a student or of the school community would be adversely affected by the inclusion of a person with catastrophic health issues, then you may have an argument. No other considerations but these 3 are going to be taken into account. All right, so the fact that you may decide that you are not a school that accommodates people with learning issues is not a valid consideration. I hear this argument all the time. Well, we're not a school for kids with learning problems. The problem is twofold. One, the legislation or the court will not permit that as an argument for avoiding the situation. And secondly, you may find yourself in a situation where once a student has been admitted to your school, you discover through the process of observation that this student does have an exceptionality and does require an accommodation. As a school, then, you face a dilemma. Are you going to ask that student to leave your school because they require an accommodation, or are you going to come to some sort of compromise and find a way to make the school environment appropriate for this particular student? So it is a situation that you have to take into account. To claim the undue hardship defense, the organization responsible for making the accommodation has the onus of proof. All right, it's not up to the person with a disability or an exceptionality to prove that the accommodation can be accomplished without undue hardship. A mere statement without supporting evidence that the cost or risk is too high based on impressionistic views or stereotypes will not work. A private school, more often than not, would claim the undue hardship defense on the cost provision. Okay, so costs will amount to undue hardship if they are quantifiable, if they are shown to be related to the accommodation, and they are so substantial that they would alter the essential nature of the enterprise, or are so significant that they would substantially affect its viability. In other words, if providing an accommodation is going to bankrupt you, and you can show that, you can't just say it will, if you can show that, then you may have an argument that will work. Now, in my opinion, most accommodations that you would be asked to make and that you should be prepared to make will not be so catastrophic that it should have a cost attached to it that would be prohibitive. But that's for individual schools to determine. But be prepared to provide financial statements, expert opinions, detailed information about the accommodation requested and why you would find that difficult, and empirical studies supporting your arguments. If you can't do that, you need to find a way to employ the accommodation. Child Care and Early Years Act and Memorandum Number 9. The reason I'm pointing this out is because the Child Care and Early Years Act has amended the Education Act to make it clear what the responsibilities and obligations of schools, particularly principals and teachers within that schools, with respect to child protection. One of the things that we see from time to time in schools, and sometimes have trouble understanding how to deal with, are children that appear to be in need of protection for one reason or another. This act states unequivocally that if any person, including a teacher or principal or another professional, has reasonable grounds to suspect that a child is or may be in need of protection, the act requires that that person report his or her suspicions forthwith to a Children's Aid Society and provide the information on which the suspicions are based. It's not something you can elect to do or not. You are required to do this. Now, why should you be concerned with that requirement? Well, aside from protecting the health and well-being of the child, the second reason that you need to be concerned is that you don't want to be held liable should it turn out in a longer term situation that the child has been subject to actions that threaten their health or well-being that you were aware of and failed to report. You will have a serious legal problem. Subsection 72(3) of the Act provides that every person who has reasonable grounds, all right, to suspect that a child is or may be in need of protection needs to report that and must not rely on anyone else to do that. It's an ongoing obligation. So it doesn't stop with that first report. If there is further evidence that needs to be presented, you have that obligation. All right? The consequences of not reporting would, the least that will happen upon conviction would be a $1,000 fine. This, of course, does not cover any possibility that a lawsuit could be brought and whatever damages could be brought there. So one thing I might also suggest that you do is check your liability insurance and see whether or not you have any sort of coverage at all that helps protect you in these kinds of situations. I'm giving you an excellent example of how to construct a template. It's from the Blue Water District School Board. You can adapt this to meet your own school needs. So this would be a blueprint for reporting instances where you feel a child is in need of protection. Sexual harassment and sexual abuse have been issues that have dominated discussions about safety and conduct, inappropriate conduct in recent years. I'm going to leave specific discussion of protocols governing this to webinar 4, where I'm also covering bullying. I've put that together there because it requires a more extensive discussion. Here are examples of ministry education policy memoranda that are applicable to safe schools planning. So I've listed them there. You can find a more complete list or more comprehensive list on the ministry website, but you should have copies of all these things on file in your school. If you don't, you should be uploading them or downloading them, whichever is applicable. Downloading, I think, and copying or printing these and keeping files so that they're handy for easy reference. Generally speaking, the ministry is fairly good at sending copies of these policy and program memoranda to individual schools as they are created. But again, they are available on the ministry website. Regulations under the Education Act. Here are some places you can go that may be of use to your parents and guardians in terms of some of the issues that you will be dealing with when it comes to safe schools. I'm including the identification and placement of exceptional pupils and special education programs and services because I do believe there may be some participants today who are in fact running schools where special education programs are offered. If they are not applicable to you, then obviously you don't have to reference them, but in terms of what I've had to say already today, you may want to acquaint yourself with these sorts of things in any case, just in case you get a request from a parent or a student. Okay, safe access protocols. The Ontario government has introduced a regulation that addresses access to school premises. That should read March 2017. Under this regulation, you are obliged to control access to your school and its component parts. So there is a link there again that you can follow that will give you access to that piece of legislation, but here are the highlights. Your controlled access guidelines should include the following items. Statement of authorization and consequences for violation of the access policy. Persons who are permitted on school premises, reporting procedures for indicating unauthorized access, designation of off-limit areas in the school, persons not permitted on school premises. An example of that would be a suspended or expelled student. And also it should contain some reference to the Trespass to Property Act, because that's the piece of legislation that you would normally invoke if you wish to press charges against someone or a group of individuals who are either accessing or attempting to access your property unauthorized. Under the Safe School Act, it's the principal of the school that has to implement that policy and also a safe arrival protocol. Each one of you will have to develop a safe arrival protocol that is customized to your school situation and to your school timetable. It has to be a reliable system of communication with parents and guardians, and it has to cover such things as absence from school or a medical emergency. For instance, I was working in a private school here in Ottawa in the months before Christmas, and in order to access the school, I had to press a button on an intercom and have someone in the main office of the school inquire as to who I was and what my business was in the school, and before I could be admitted. I think that's a good policy, some sort of system that involves either intercoms or cameras or both of those would go a long way to ensuring that your place of learning is secure. The thing that I noticed, however, about this school was that whereas access to the school was well covered, the system of communication with parents and guardians was incomplete. Yes, communication for absences from school and so on seemed to be in place, but there was incomplete or non-existent information with respect to those types of pieces of information that would be necessary should a medical emergency occur, or if parents themselves were unreachable. So it's really important that you develop something like the office index card, either in writing cursively or on the internet, electronic, that includes contact information for parents and guardians, but also emergency contacts. And you should be able to reach somebody. If you can't, again, the principal would be responsible for making sure that the appropriate people are notified. If he can't reach anyone, then calling the police is the next best option. I don't know how many of you there have school transportation situations, but if you do, then your guidelines, your school transportation guidelines, should be a part of your safe school plan. So you need to have policies and procedures that govern students' movement to and from the school and transportation for the purpose of field trips and extracurricular activities. So even though some of you may not have a busing situation to get from home to school and back, many of you will still have transportation for the purposes of field trips. So those policies have to reflect what type of transportation you're using, the transportation provider, which would include a third-party agreement, and then there has to be guidelines for the school, the transporter, parent, and student responsibilities, and a code of conduct. So this code of conduct could be drawn from the overall school of conduct, but it should also be specific to transportation. There should, if you have it, a guideline for parent-teacher transportation of students, but OFIS is not recommending this as an appropriate form of moving students for field trip purposes. And I think the reasons for that should be quite obvious. They're mostly liability issues. And if you, as a principal, are asking a teacher, for instance, to take on that responsibility, they would be well within their rights to refuse that as being unacceptable. There should be a form that you have that's filled out whenever there's an incident on your bus or your transport. There should be a list of the items that people are allowed to carry with them, and there should be a policy regarding what happens if the buses aren't running or if there are accidents. Also, there are some schools that allow electronic devices. As long as they're not distracting, I don't see any particular reason why that shouldn't be allowed, but that's again a policy that needs to be determined on a school by school basis. In big, bold letters here, I have indicated that you need to be sure that you're carrying adequate liability insurance and that you are in compliance with the terms. In other words, read the fine print. All right, so today you've had the opportunity to review some of the more important requirements that you will need to meet as a school leader in the establishment of a school safety plan and the development of a safe, caring environment. In subsequent seminars, we will deal with more specific information on bullying prevention and intervention, building better behavioral protocols, incident reporting protocols, data protection and confidentiality, information on technology and social media, first aid, alcohol, smoking, and drugs protocols, and emergency and crisis response protocols. So I want to thank you all very much for your attention, and I'm going to open the floor now for any questions that you might have.
Okay, so if you have questions, you can type them in to the message pane on the right side of your screen, and I will ship those questions out for the entire group to hear, and David can give a response. I've also opened a Basecamp. So this is a virtual project room where I have begun to already post some of the documents that David has referenced. I've posted his presentation from today, and I've invited all of you to join that. You can also post questions there later if you are working on pieces of policy and you have questions. So does anyone have any questions right now? Feel free to go ahead and type those in. David, I'm not seeing any questions yet. Do you have any other sort of comments that you wanted to make, maybe that you didn't get to make because of your concern over the time?
Only that, we only have about 10 or 12 minutes for questions or discussion. I wouldn't mind hearing from participants whether or not there are specific areas of the presentation where they would like additional information.
Okay, I'm going to leave it open for maybe another minute. And if we don't have any questions from any of our participants, I'm going to suggest that we shut the webinar down, and I will continue to post the rest of the items in the Basecamp. You can accept your invitation to the Basecamp. You should have already received it. And, oh, Franklin's telling me that there are questions, but I'm not seeing them.
Okay.
That's interesting.
Are they hearing you?
They are, well, I think so. You're hearing me, so.
Oh, I am.
Yeah, I'm just looking to see why I'm not seeing these questions.
So if you're not seeing them, Barbara, it's Franklin here. I'm happy to read them out if that will assist.
Okay, that would be great actually, because I am not seeing the questions.
Okay, so clearly something went a little awry on the technical side. So I'm happy to read them out. So the first question then, I'm not going to be giving any names here. I'll just read the questions as is.
Sounds great.
One attendee has asked, can we write into our policy what type of student we accept?
Personally, I would not do that. I would make that part of my application process. So at some juncture, you should sit down with your school team and determine exactly how it is that you want to phrase that sort of position. And the reason I'm saying that is because if anyone can claim that by virtue of your statement you are displaying a bias of one type or another, then you are going to have some issues that you're going to have to deal with. So I think that what you need to do is build in to your application process a test or some sort of admission responsibility that a student has that you will assess as part of that admission process. And that will allow you the ability to indicate that you feel the student is not suitable for your school environment without explicitly saying we're not going to take kids who are dyslexic, for instance.
Fabulous. Thank you very much for that. So we've got a number of questions coming in. So David, clearly you're an engaging presenter. So the next question is, are there specific differences with regards to suspension in elementary schools and secondary?
The answer to that is yes. And in a webinar that's upcoming, when we do bullying and codes of conduct and things like that, I will be dealing with those things in more detail. But essentially, just to give you a preview, I suppose, of that presentation, what we're looking at now in both elementary and secondary schools is a policy of progressive discipline. So as I said, zero tolerance is no longer the status quo. We're looking at progressive discipline. And I think I did mention that the principal or whoever you have appointed as the person responsible for this is to take into account mitigating circumstances, but you'll also take into account the level of maturity, the age, and the psychological status of the individual before you decide not only the level of consequence, but within each of those levels, gradations that best suit situations on an individual basis. So if you ask me whether I would treat a student who is 10 years old and in grade 5 the same as I would treat a 17-year-old in grade 12, even with respect to suspensions, the answer is no. I would not, and I would be much more hesitant to consider expulsion as a remedy for a student in elementary school than I would a student who's close to the age of majority. We have to take into account that you would expect, in most cases, a 17-year-old to have a much firmer grasp on what's appropriate and what is not than a 10-year-old.
Fabulous. Thank you. Thank you. All right. The next question is relating to gender-neutral bathrooms. And the
Yes.
question is, do separate bathrooms count? They are there for adults, but is that sufficient for students?
I'm not sure I understand the question. If you're asking me whether you need to have a gender-neutral bathroom, the answer is yes.
I believe,
whether it's adults or children or anything or anybody else.
I believe, if I interpret this one correctly, and I think the individual who typed this in could also type in if I'm interpreting it incorrectly, but I believe the interpretation here is that this facility might have separate bathrooms, male, female, for adults. Is that going to be sufficient for the students as well?
No, you have to have a gender-neutral bathroom, whether it's students or parents. What if you have a parent who is identifying as, gender-neutral? What if you have a parent who is transgendered? The law indicates that gender-neutral facilities be made available. And I don't think it has anything to say about whether you're talking about adults or young people. Does that answer the question or no?
Okay, well, I will leave it at this point to the individual who first posed that question. Perhaps they, if it hasn't addressed it, they can either, if we have time and they type in
There's nothing wrong with having bathrooms that are for the parent or for adults and bathrooms that are for students, but there must be the provision for gender neutrality in either case.
Fair enough. All right. Another question. From the PowerPoint, we can see that you shared with us something from Blue Water District School Board. When crafting policies, should we be looking at the policies of various school boards?
Well, as I indicated, it's always a good idea to make sure that you're in line with what's happening in the public sector, because that's the standard to which you will be held. The problem with relying too much on board policies or programs is that not all of them are created equal. Some are much better than others. You'd be much better off to use ones that we either recommend or to go to the ministry program and policy memoranda themselves and generate your policies from those, because the ministry itself, for instance, will have a number of templates, some of which are very good, that you can customize to your own situation. That is something that OFIS can help you with and will down the road upon request.
Fabulous. Thank you. We have a couple of I'll just take a break from the questions for a moment. We have a couple more, but we also did receive a few compliments from attendees, so thank you very much. One person wrote, "Thank you, David. Thank you, Barb, and thank you, Franklin." So that's always nice to get positive feedback, so thank you very much.
Sure.
All right, another question. Is it true that as a private school, we are not required to provide a reason for not accepting a student?
Yes, but not advised. Yeah, you don't have to tell someone why you didn't accept a student, but unless you're worried about the consequences of your response, I would do two things. Not only would I give them a reason, I would offer to assist them in finding a placement that is more applicable to their child's circumstance.
Okay.
So in other words, if I'm a school that's offering an IB program or an AP program, and I have a student who wants to come into the school who's coming from a vocational school, and my entrance examination indicates that the student would flounder in my situation, I would have the parents and the student in, we discuss the situation, and I would offer to find them a situation that's more suited to their particular situation. That's what I would do.
All right. Thank you, David. All right, another question. Can we have a parent agree that they will waive their right to have us find another school if, I'm assuming they say we, if the family or the school expels that student or students for legitimate cause?
Can you have them waive the responsibility?
Yeah, the question reads, can we have a parent agree that they will waive their right to have us find another school if we expel them for legitimate cause?
Why would a parent ever agree to that? I'm sorry, Dad, but I'll ask the question back. Why would a parent ever agree to waive that responsibility? You can't coerce them into doing it. So I can't think of a reason why a parent would waive that right.
Okay, fair.
Any more than I could see them waiving the right to ask for accommodations.
Good. Okay, thank you. And there's one other question. It's written more as a comment, but I think it relates back to the gender-neutral bathroom discussion.
Sure.
Right. And the comment in here is typed, so we need to remove men and women and just put the word washroom on all their bathrooms.
So are all the bathrooms going to be gender neutral? Again, I can't answer the question unless I know the circumstance. What I did in our school is I had one bathroom that had the male symbol on it. I had one bathroom that had the female logo on it, and I had a third bathroom that had the co-joined symbol. So it could be either male or female, or neither.
Okay, fabulous.
I didn't use words. I used symbols.
Great, thank you. I do not see any other questions typed in there. And since it's 2 or 3 minutes left to go till the top of the hour, I will hand it back over and invite Barbara to finish up.
Thanks, Franklin, for taking the questions. I still am not seeing them here, so you and I will have to discuss that offline. Just wanted to thank everybody for participating today and to encourage you to accept your invitation to the Base Camp discussion group, where I have posted the relevant documents and some of the other pieces that David spoke about today. And if there are any ongoing questions, they can be handled there as well. So thank you everyone for attending, and we look forward to hearing and seeing from you next week.